Hello everyone and welcome to the first of our video tutorials on contract terms. In today's video tutorial, we're going to be looking at an introduction to contract terms and looking specifically at express terms in a contract. The contents of a contract are known as terms or clauses, and an agreement will generally consist of various terms. And even the simplest forms of contract will have terms. The main terms are generally things like the price paid and the subject matter of the contract. And it's common for businesses to have standard form written terms which can be quite lengthy. It is not a requirement that terms are written in really simple contracts, although writing is required in certain types of contracts, such as contracts for the sale of land, mortgages, and consumer credit agreements. Contract terms can be express or implied, and today we're going to be focusing on express terms. And terms can be further classified as either conditions, warranties, or innominate terms. Where a contract is formed orally, it may be difficult to establish which statements made in the lead up to negotiating the contract amount to terms and which statements are merely representations. And we're going to be having a bit of a closer look at that today. To start with then, if I just introduce you to the two key types of terms that we're going to be looking at in this topic, there's express terms, which we're looking at in this tutorial. And in a later tutorial, we're going to be looking at implied terms. So express terms are written into the contract, or they might be orally agreed, and we've decided that they're not representations, they are terms, but they've been made verbally. The other type of terms that we have are implied terms, and these are terms that, although they haven't been agreed by the parties themselves, they are implied or put into the contract either by the courts or by Acts of Parliament. And as I say, there's going to be a separate video tutorial focusing specifically on these. Today we're going to be focusing on express terms. So if we start looking at express terms in more detail, then you can see from the diagram that express terms, we've got two types of express that are written into the contract, and as you can imagine, that makes life a little bit more straightforward, because if the terms are clearly written into the contract and that's all been signed, we can see what the parties have agreed to. The more complicated area is where there's an express term that is being discussed by the parties, but it's not being written into the contract. It's been orally agreed. Now, when we're looking at express terms that are orally agreed, we have to be sure that they're not representations. And it's actually a little bit more complicated than that even. So if I go onto this slide here, when we're looking at verbal conversations in the run-up to negotiating a contract, there are three things that these verbal conversations can amount to. It might be that the discussion is just a puff. It might be that it's a representation, or it might be that it is in fact an express term, which is what we want if we want to be enforcing it in the contract. So as a bit of an introduction today, we're just going to consider what's the difference between a puff, a representation, and a term. So all of these three things, puffs, representations, and terms, are all pre-contractual statements. They are all things that might have been said verbally before the contract was entered into. And if we start with a puff then, it says here that it's a statement that no reasonable person would take seriously. And that's because a puff is a statement which cannot give rise to legal consequences. They're never meant to be taken literally, and there's no intention to be legally bound. And if I just show you some examples, you frequently see puffs or puffery in advertising media. I've just found a few examples from the internet here. These are things that would be classed as puffs. And you can see when you look at them that it's not meant to be taken literally. So if you look at this Burger King one, it'll blow your mind away. Obviously, it's not literally going to blow your mind away. A lot of them are a bit nonsensical. I've seen toothpaste adverts that have said things like, it'll make your teeth whiter than white. So that's just puffery. It's not meant to be taken seriously, and there's no legal consequence for these. I go back to the previous slide then. So we've seen what a puff is. A representation is a statement of fact which we've decided it was made before the contract was entered into, and it's not part of the contract. If it's false, you can sue in misrepresentation, which we're going to study later on in contract law. So if someone makes a representation to you which is false, you can sue them in misrep. The final thing that the pre-contractual statement might be is that it might be a term. And this is a promise or an undertaking that is part of the contract itself. And if a term is broken, the claimant can claim for breach of contract. So to summarise then, what we're seeing here is that these are all types of pre-contractual statement. And the reason it's important to know which your statement is because that's going to affect what action you can take. So with a puff, that's not meant to be taken seriously. It's like a throwaway advertising gimmick. And you can't do anything if there's a puff. There's no remedy if the statement's wrong. Representation is not part of the contract, but if it's a misrepresentation, if the statement of fact is false, then our claimant can sue in misrepresentation. But the best option, if you want to sue in contract law, is that you can prove that the pre-contractual statement was a term. And in this case, you can claim for breach of contract, which is what you want. So what we need to look at now then is, how do we distinguish between a representation and a term? Puff doesn't really matter to us now because we've seen that's just an advert and you can't do anything about that anyway. But how do we work out, is a pre-contractual statement a rep or a term? Because if it's a rep, we can sue in misrep. If it's a term, we can sue for breach of contract. So that's what we're going to look at now. In order to decide whether a pre-contractual oral statement is a representation or if it's a term, the courts have developed some guidelines on this. So we're going to have a look at importance of the statement, knowledge and skill of the person making the statement, and the timing that the statement was made. The first guideline for deciding whether your pre-contractual statement is a rep or a term is looking at the importance of the statement. If the individual relying on the statement makes it clear that the statement was of such importance that they wouldn't have contracted without that guarantee, then the presumption is that the statement will be a term. And this rule is illustrated in the case of Bannerman and White. In Bannerman and White, a buyer made it clear that he didn't want any hops that had been treated with sulphur. And the seller mistakenly thought that his hops had not been treated with sulphur and made a false statement. And the issue in this case was this false statement just a representation, so you can sue in misrep, or was this false statement actually a term so that you could sue for breach of contract? And the court looked at this and they decided that the statement about the sulphur was incorporated into the contract, i.e. it became a part of the contract as a term, because the buyer would not have entered into that contract had it not been for the statement. So in other words, the more important the statement is, the more likely it's going to be a term. Second guideline for deciding whether your pre-contractual statement was a rep or a term is looking at the knowledge and skill involved by the person making the statement. If the individual making the statement has some specialist skill or knowledge of the contractual subject matter or claims to have such knowledge, the presumption is that the statement is more likely to be a term. And this rule is illustrated in two cases which we always compare, the case of Dick Bentley with the case of Oscar Chess. In the case of Dick Bentley, the defendant was a car trader who specialised in the prestige car market and was something of an expert on Bentleys. The claimant knew the defendant had all this specialist knowledge, and he asked the defendant to find him and recommend him a good Bentley. And the defendant here looked at a Bentley and made a false statement as to its mileage. Now, the claimant trusted the defendant's knowledge, superior knowledge of Bentleys, and therefore it was more likely that the false statement, was not just a representation, it was actually a term. And you can see here that the principle is, where the representer, meaning the person who makes the statement, possesses superior knowledge and skill, it's more likely that the statement is a term. And that seems fair enough, because if you know you're talking to an expert in that field, you are going to trust that what they're saying is true, and you are likely to rely on that statement. We always compare Dick Bentley to the case of Oscar Chess, and in this case, it was another case about the sale of a car. Now, there was a part exchange happening here between a private car owner, who was just like a normal person, and a car dealer. Now, the private car owner gave a false statement to the dealer. She made a mistake. She gave a false age of the car to the dealer. Now, obviously, the car dealer is in a position to have superior knowledge about cars than just this ordinary private car owner. So therefore, although she'd made a false statement about this car, that was held more likely to be a representation, because the claimant, the car dealer, was in a position to verify the truth of the statement. So what these two cases are showing us is that if your representer has the superior knowledge, it's more likely to be a term. However, if the representer has less knowledge than the person they're selling it to, as in Oscar Chess, then it's more likely to just be a representation. And the final guideline for deciding whether your pre-contractual statement's a rep or a term is looking at the timing of the statement. And the longer the time lapse between the making of the statement and the entering the contract, the more likely that it's going to just be a representation. And this rule's illustrated by Routledge and McKay, which was about the sale of a motorbike. Both parties were just private sellers, they weren't dealers, they had no expert knowledge. The seller genuinely thought his motorbike had been manufactured in 1942 when it was actually 1930. And the court in this case decided that the statement about the date wasn't a term, it was just a representation, because there was a big time lapse between him mentioning the date of the bike and the sale. And again, I think this is pretty common sense. It seems fair enough. If the seller says it's this date and the buyer immediately goes, "Oh, brilliant, I'll buy it," then that indicates that that statement was very important, more likely a term. If, however, the seller says something and the buyer goes away and goes, "Oh, I'll think about it," and comes back a week later, then the likelihood is that statement wasn't that important and therefore is more likely to be a representation. To summarise on express terms then, what we've seen in this tutorial is that express terms can be written or verbal. With the verbal ones, we have to decide, is it a puff, a rep or a term? And the big question for us is deciding whether something's a rep or a term. And in order to do that, we look at the importance of the statement, the knowledge and skill of the person making the statement, and the amount of time between the statement and the entering into of the contract. So that's it on express terms. Please look at the next video tutorial in which we'll be looking at implied terms in a contract.